people have dreams of being successful or rich when they grow up so they can enjoy the luxuries that life has to offer. But some people achieve the luxuries, others don't. The way people achieve those luxuries is very important. If not careful, a person can end up filing for bankruptcy. Bankruptcy is nothing to joke about.
For various reasons, people and corporate entities end up in a position where they cannot pay their debts. Bankruptcy is sometimes an option to help.
What is bankruptcy? In short, bankruptcy is a legal procedure that eliminates or restructures the debt of people who cannot pay because of a variety of circumstances. There are several types or chapters of bankruptcy, but the most common are Chapters 7, Chapter 11, and Chapter 13. This video focuses on these three types of bankruptcy.
Our founding fathers were aware of the possibility of bankruptcy. Article 1, Section 8 of the United States Constitution authorizes Congress to enact uniform laws on the subject of bankruptcies. Pursuant to this constitutional authority, Congress enacted the Bankruptcy Code in 1978. The Bankruptcy Code has been amended several times since its enactment. It is the uniform federal law that governs all bankruptcy cases. The procedural aspects of the bankruptcy process are governed by the Federal Rules of Bankruptcy Procedure, often called the Bankruptcy Rules, and local rules of each bankruptcy court. There is a bankruptcy court for each judicial district in the country. Each state has one or more districts. There are 90 bankruptcy districts across the country. The bankruptcy courts generally have their own clerk's offices. The court official presiding over federal bankruptcy cases is the United States bankruptcy judge. The bankruptcy judge may decide any matter with a bankruptcy case, such as eligibility to file or whether a debtor should receive a discharge of debts. Much of a bankruptcy case is administrative in nature. In cases under Chapters 7 or 13, and sometimes in Chapter 11 cases, this administrative process is carried out by a trustee who is appointed to oversee the case. A debtor's involvement with the bankruptcy judge is usually very limited. A typical Chapter 7 debtor will not appear in court and will not see the bankruptcy judge unless an objection is raised in the case. A Chapter 13 debtor may only have to appear before the bankruptcy judge at a plan confirmation hearing. Usually, the only formal proceeding at which a debtor must appear is the meeting of creditors, which is usually held at the offices of the U.S. trustee. This meeting is informally called a 341 meeting because Section 341 of the Bankruptcy Code requires that the debtor attend this meeting so that the creditors can question the debtor about debts and property. The fundamental goal of bankruptcy is to give debtors a financial fresh start from burdensome debts.
With regards to individuals and not businesses, what are the main reasons people are forced to file for bankruptcy?
My experience has been that the main reason people file for bankruptcy are too much credit card debt, a major catastrophic illness, and loss of employment.
Chapter 7. It's considered a liquidation under the United States Bankruptcy Code. In a Chapter 7, the debtor's non-exempt property is sold and the proceeds are distributed to the creditors of the debtor. To qualify for relief under Chapter 7, the debtor may be an individual, a partnership, or a corporation or other business entity. The order and how much the creditors are paid is determined in accordance with the provisions of the Bankruptcy Code. Not all of the debtor's property can be sold. Property that has a lien or a mortgage on it might belong to a specific creditor. Also, the bankruptcy code will allow the debtor to keep certain exempt property. A person does not automatically get the right to file a Chapter 7 bankruptcy. If the debtor's current monthly income is more than the state median, the bankruptcy code requires certain tests to be applied to determine if the Chapter 7 filing is appropriate. Bankruptcy law is federal law. However, each state allows certain exemptions to be declared in a Chapter 7 and 13 bankruptcy. For example, in Florida, things like a person's home is exempt, motor vehicles valued up to $1,000, and Social Security and disability benefits are exempt. A person's home is exempt or vehicles are exempt only if they're paid for. If a Chapter 7 bankruptcy is successfully administered, an individual debtor gets a release called a discharge from personal liability for most debts. Business entities do not get a discharge in Chapter 7. Sometimes a discharge is not granted if, for example, the debtor does not cooperate during the bankruptcy, or it is discovered that the debtor was fraudulent or concealed assets during the bankruptcy.
Chapter 11 is known as a reorganization under the Bankruptcy Code. It usually involves a corporation or partnership. A Chapter 11 debtor proposes a plan of reorganization to keep its business operating and pay its creditors over time. Stated simply, creditors of a Chapter 11 debtor file claims in the Chapter 11 bankruptcy. Ultimately, a plan of reorganization is drafted that details what creditors are getting paid and how much they are getting paid over a certain period of time. A plan of reorganization must be accepted by the creditors and approved by the United States Bankruptcy Court. The Bankruptcy Court enters an order that confirms the plan.
Chapter 13 is used by individuals who have debts along with regular income. Chapter 13 allows a debtor to keep property and pay debts over time, usually over a course of 3 to 5 years. The plan can never be more than 5 years. Chapter 13 is most frequently used by individuals who want to save their homes from foreclosure. By filing a Chapter 13, individuals can stop foreclosure proceedings and pay delinquent mortgage payments over time. However, the Chapter 13 debtor must stay current on all future payments as they become due during the Chapter 13 bankruptcy. To state it simply, a Chapter 13 debtor gathers all the debt they owe on the day they file for bankruptcy and comes up with a plan that lasts 3 to 5 years to pay this debt back. But, at the same time, the Chapter 13 debtor must stay current on the cost of property he or she wants to keep, for example, a house or a car. A monthly payment is made to a bankruptcy trustee, and the trustee distributes payments to creditors. Once the Chapter 13 plan is confirmed, the debtor must make regular payments to the trustee, as well as regular payments to keep secured property like homes and cars. While in the Chapter 13, the debtor may not take on new debt without consulting the trustee because the additional debt may affect the debtor's ability to successfully pay the plan.
Out of chapters 7, 11, and 13, which chapter do you normally take cases on and why?
The cases I'm primarily involved in are cases that are pending in either Chapter 11 or Chapter 7. The reason I am primarily involved in Chapter 11 is Chapter 11 is the bankruptcy provision that generally deals with corporations, partnerships, or wealthy individuals who have filed for bankruptcy in order to restructure their finances. And given the amount of money at stake and the creditors that are involved in a Chapter 11, those type of creditors generally hire my firm or myself to represent them in a Chapter 11 case. The next chapter that I'm primarily then involved in are Chapter 7 cases, which are liquidations. Chapter 7 cases are straight liquidations in which a corporation, an individual partnership, basically have their businesses ended and they're liquidating. And the clients that I generally represent in Chapter 7 are either secured creditors who are secured by collateral or assets that have been pledged to my clients in order to secure the repayment of a loan, or large unsecured creditors who are owed a lot of money and are looking to try to maximize their recovery in a liquidation.
Thank you. Okay, so what are some ways to avoid bankruptcy?
Well, as I stated earlier, I think having too much credit card debt is a primary reason that many people have poor credit and are forced to file bankruptcy. So I think one of the primary reasons that people can do is establish a reasonable budget and live within that budget, which means understanding what are your wants and your needs. I mean, everybody needs shelter, clothing, food, transportation, but not everybody needs to live in Avila, drive a BMW, go out to dinner every day. Those are wants, and I think people need to understand their economic situation, establish budgets, begin living within their means, and to use credit cards only when necessary, and not to use credit cards to pay for things that really they cannot afford and are wants rather than needs.
To sum it up, bankruptcy is a way for people to get their financial lives on track. However, it is not an automatic right, and debtors must establish that they are entitled to the protection afforded by bankruptcy law. It is very wise to watch your spending habits and not end up filing for bankruptcy.